Yeah. You might use since they they're in the there. Like I don't know if this nice place.
So,
Yes. And I'm sure they all speak excellent.
it's like their systems needs for 8 weeks, 6 weeks, and they
Yeah.
but the rest there is like, elites.
Yeah.
So it's subtitle, and they are just exposed to it.
And also,
Like,
yeah, it's just less. Pieces, right?
Yeah.
They're the voice where.
Yeah, but it's like,
Yeah.
loss.
Exactly.
They all go in language. It's like, I almost feel it from. So,
Yeah.
Are we all set, Mr. Torterola? We still have 1 minute left.
We are ready.
Okay.
Thank you very much.
Ms. Menaka, are you ready?
Yes, we are. Thank you.
Excellent. So welcome to the second day of this hearing, especially for those logging in from Guatemala, for making the extra effort, being this early up and joining us. Perhaps I should have said that in Spanish. Muchas gracias por hacer el esfuerzo de unirse.
Thank you for the effort to join the hearing this early, to be here with us on the second day of the hearing. The tribunal really appreciates the committee. The committee appreciates the effort made.
Any housekeeping issues that the parties would like to raise? Yes.
One
Okay.
housekeeping issue. Yesterday, Professor Jones made a question about one of his articles. I will be referring to that article. That article is not part of the record. So in order to avoid any issues, I would like to raise that I will be responding to Professor Jones, and I will be making reference to his article, reading from his article. The article is not in the PowerPoint presentation.
Ms. Menaka, any comments?
So I defer to the committee on this, whether they feel that's appropriate in light of the question, although it's not in the record, or if not, I defer. Given that it was a question,
Did you read the article? Are you aware of its content?
I personally did not read the article, I would say last night or this morning, but I will read the article. Some on my team may have read the article.
Any other housekeeping issues?
No, I would just would like to say that time has been given to read the article. And
Okay,
well, I need to make the point
okay.
for the record. Thank you.
Any other housekeeping issues, Ms. Menaker, that you would like to raise?
We don't have any, but what is the committee's ruling on the issue?
Let's see. It's just
Okay.
if there were other things that would just, be sure that there's no other things that we need to discuss about. So that is all. Good. Then let us just have a quick talk.
¿Cómo vamos hasta vamos ahorita?
Usted habla primero.
¿Yo hablo primero?
Sí, sí, usted habla
Ok.
primero.
Y eso pues revisamos el argumento.
¿Mm?
Perfecto.
Yo lo presento.
So I haven't read the article either. I was just told by the author of the article that it's a 40-something article, so pages, large article. So it's not like something you could just quickly read and make your comments about. Guatemala has done the effort. The question was raised, and hopefully you with your team can make the effort of listening to what Guatemala has to say about the article, make your own comments on the article. We will let the article be part of the record because it expresses a view of one of the members of the committee on an issue that has to do with those issues discussed in these proceedings. So we think it has some value and it should be in the record, and parties should be given the opportunity to comment on or to have it in consideration when they express their views. We still have not decided on whether there will be post-hearing briefs, but in view of all the things that have been said here, I think it would be useful if we were to have post-hearing briefs, and there both parties would have again the opportunity, after having carefully read the article, to express further views on what is said there. So we would like to make sure that claimant has the opportunity and is given proper time to go through the article and to comment anything if it so wishes.
So thank you. I have no objection to the article being, placed into the record. And of course, we want, an opportunity to comment on it. As far as the post-hearing briefs, and we can defer this conversation until the end of today. But, I would also want to know if we are going to have the day tomorrow, because if we are going to have the day tomorrow, then I would also ask, of course, if we could supplement any comments, on the article tomorrow. And I would also just impress upon the committee again our views, which we've expressed earlier, that I think we ought to have one or the other, a day tomorrow for questioning or post-hearing briefs, which we again believe really are not necessary or extremely rarely used in annulment proceedings. And if they were going to be in place, should be, quite limited to, ideally specific questions with page limitations, just because the proceeding, again, has gone on for
We are perfectly
a long
aware of
time.
that, but we have a rather large list of questions to the parties. And I think if I were in your shoes, I'd rather be given the opportunity to express my view in writing, where I've got, it's easier and it's a lot more comfortable than you being ambushed tomorrow with 50 questions and that we shoot them and you have to answer them. So I think it's in your best interest. And I do accept, of course, your views, not limitless posturing briefs. We can agree on a certain number of pages, but I think it's in your own interest that you may express your views on our questions in writing with the full support of your team and everything, and that you properly refer to what you say with footnotes and everything. We have many questions for the parties. I can anticipate that.
Understood. And again, not to prolong this, will you be giving us those questions, or have you not decided, but will you perhaps be giving us those questions tonight?
We will
or
try to
later?
compile them tonight, and if possible, if not tomorrow, we will read them out loud. We will provide them, so we may explain a little bit about the questions, so you don't get them cold and out of nowhere and without a context. And then we can talk about possible posturing briefs, and perhaps in view of the list of questions, you may, alter your view and say, yes, we do prefer to
Sure.
answer them in writing.
Sure. Thank you.
Yes.
Can I just say something?
Sorry,
Can I just say something?
them? Could they say? I do.
Yeah.
Of course you can. You sure?
Yesterday we were a bit jammed for time, and I had a question which may well form part of the tribunal's questions for tomorrow, but since it relates to a document not in the record, I thought it might be useful to ventilate it now, just in case parties wish to consider and deal with the question during their submissions. The question is this: a process has been underway for some time jointly between ICSID and UNCITRAL in developing a code of conduct which deals in part with the requirements for disclosure by tribunal members. Version 4 of the draft code was issued this month and deals in paragraph 2A Roman 3 with disclosure in respect of relationships between counsel and experts. In each of the versions of the draft, there being 4 now, notes have been provided for discussions within the working group with commentary. My question is, what is the relevance, if any, of this work in respect to the duties of disclosure by tribunal members regarding engagement between counsel and experts? What notice, if any, should the Annulment Committee take of the work that has been undertaken and its timing, in addition to the views of other annulment committees on this question, which the parties have already referred to in their submissions?
Professor Jones.
I'm reminded that the paragraph number I mentioned is part of Article 10 of the fourth draft.
I would like to say that I would be very happy to respond to your question. I will include some of those considerations in my remarks today, but I would like to also reserve the right to comment on that further. I know I'm very aware of the discussions that are taking place in UNCITRAL and ICSID. I attended myself to those negotiations on behalf of a sovereign state. But I have to confess that the exact rule of the new version of the Code of Conduct, I have not had the opportunity to read it and to reflect upon it. I will put some of my thoughts in my presentation now, but I also reserve the right to respond on that further tomorrow and if necessary on the post-hearing briefs, but I will do my best to provide you with a response tomorrow.
A lot of the publicity surrounding this work, which is still in draft, deals with double hatting, as you would be well aware. But there is a specific reference to disclosure in the context of counsel and experts.
Thank you very much, Professor.
Yeah, we're also aware of that, the development and the content of the rule, and can also comment about it today and further elaborate tomorrow, as well as the applicability or non-applicability of it or relevance.
Excellent.
Yes, one extra issue. We have the printed copies for the tribunal. We have an extra copy now for the opposing counsel. More copies are coming.
Council, whenever you're ready. Oh. Shall we just wait? Yeah, I'll keep going. Good. Good.
Estamos listos, señora presidenta.
Muy bien.
Va a comenzar el señor procurador.
We are ready. Madam President will hear the Attorney General. He will be speaking in Spanish first. And I'm just,
We can do that for Professor Jones. Professor Jones, we can do that.
Turn it over as you speak.
Okay.
Pues vamos a esperar un minuto a que el
let us
trabajo de
wait
encuadernación-
for a minute.
Oh, just about finished.
Mientras tanto, si podemos probar el micrófono del procurador Gómez para
Can we
asegurar.
just test mic with the Attorney General? This is a test.
¿Le llega bien
Test.
la pista? Perfecto. ¿Y la interpretación también? Perfecto, Trevor. Can you-
So, yes, we can hear it fine.
Do you need a new binder or do you want to just add it to the other?
Thank you very much.
Cuando usted quiera, procurador. Muchas gracias.
Whenever you're ready, Attorney General, good morning. Honorable members of the Annulment Committee, ICSID representatives, representative for TECO Guatemala Holdings. My name is Wilmer Gonzalez. I am appearing here as Attorney General for the Republic of Guatemala, and I will be starting here with the closing remarks of the state that I am so proudly representing in this hearing. This representation also entails a high duty to promote the defense of the rights of Guatemala in the international field, according to Article 252 of the Political Constitution of Guatemala and law that rules the work of the Office of the Attorney General. Next, I will be referring to the arguments and the reasons that justify the annulment of the second award. First, I should mention that as the main principle that is enshrined in any legal system, the right of the parties to be heard and judged by an impartial tribunal. Without that, it is impossible to think of the existence of law itself. Clearly, the ICSID system is not an exception, since the arbitrators need to remain impartial and independent from the outset and up to the end of the arbitration. This principle was clearly breached in the second arbitration. As Counsel for Guatemala indicated yesterday, Dr. Alexandrov, an arbitrator appointed by TECO in the second arbitration, breached its right to clearly state the professional relationship that he had with the expert on damages, Mr. Kasmarek, and his company, Navigant Consulting. When the respondent is a state, this becomes extremely important because an adverse decision issued by an arbitral tribunal has an impact on the whole population, because the payment will be made with monies from the country. It is concerning for the Republic of Guatemala that at the end of the second arbitration, they learned that Mr. Alexandrov and Mr. Kasmarek have worked representing the same party during at least 7 arbitration cases, as indicated yesterday by Guatemala's council. 2 of those arbitrations are Spence v. Costa Rica and Lidercom v. Peru were underway, while the second arbitration was still underway. In the case of Liderman v. Peru, Mr. Alexandrov, as party counsel, was working with Mr. Kasmarek in the presentation of experts' reports. And at the same time, the same person, Mr. Alexandrov, now as an arbitrator, was leading and analyzing the expert reports that were drafted by Mr. Kasmarek for the second arbitration. It should be underscored that it is not the same time that the relationship between Mr. Alexandrov and an expert on damages is being questioned, at least in 3 cases: TCC v. Pakistan, Soles v. Spain, and ICER v. Spain. Such a relationship had already been questioned, and in the case of ICER v. Spain, the award was completely annulled, even though Mr. Alexandrov knew and was completely aware of his relationship with an expert on damages. This had already been questioned in other cases, but he chose not to tell the parties this information, in particular Guatemala, that had the right to know, and this limited their right to defense. The other party is erroneously trying to say that Guatemala was responsible for knowing about these relationships. This is just an attempt to deflect the attention, because it was Mr. Alexandrov, the one who should have communicated this, since he was more informed than anyone about this. TECO is erroneously saying that Guatemala has waived their right to object and question these relationships, but it is impossible because the state did not know of their existence. Therefore, they were not able to object. In Guatemala's opinion, these circumstances clearly and objectively showed the partiality or bias that Mr. Alexandrov maintained in the case. As the state indicated in their pleadings, an award issued by a tribunal without independence and impartiality at any point of the proceeding is subject to annulment. As a result, the grounds for annulment invoked are: number 1, the improper constitution of the tribunal according to 52(1)(a) of the ICSID Convention, because of the lack of impartiality of Mr. Alexandrov. And number 2, a serious departure from a fundamental rule of procedure according to 52(1)(d) of the ICSID Convention based on the breach of the right that arbitrators have to communicate the information for the right of defense that Guatemala has. Secondly, the ICSID Convention states that also the awards need to be reasoned and explain the various reasons that led to the tribunal's decision. The reasoning should allow the parties understand the rational process that was used by the tribunal to reach their conclusions and decisions without the need to resort to the record or to the case. In that regard, the determination of future damages in the second award lacks reasoning, and it also includes mutually excluding contradictory arguments. To establish the but-for valuation of ICSID that was key for the estimation of future damages in the second award, the tribunal did not reason or explain why they used the valuation presented by Mr. Kaczmarek, and as a result, they paid no attention to the valuation presented by Guatemala. In addition to this award has clear contradictions. To sum up, it was established that historical and future damages were of different nature as indicated at 81, 82, and 83 of the second award. However, at paragraph 104 of the same award, it was indicated that both damages had the same reason and future damages were an extension of historical damages, and it is a logical inconsistency that makes the award annullable. Because of what I just mentioned, the reasons to annul the second award are serious departure from a fundamental rule of procedure according to 52(1)(d) under the ICSID Convention because of the breach of the right to defense that Guatemala had, and also because there was no proper assessment of the evidence presented by Guatemala, and there is also a failure to state reasons for the award according to Article 52(1)(e) based on the failure to state reasons, and also because they used the evaluation by Mr. Kaczmarek that included contradictions. And third, the second award also was a manifest excess of powers since the decision was beyond the provisions under the ICSID Convention, and this had to do with the risk-free interest rate for future damages that had to be applied for the following reasons. First, the inexistence of risk for future damages had to be applied for the following reasons. The lack of future damages for TECO, for commercial risk for TECO, because in 2010 they sold their ancillary participation in EXA, and second, because the rate was established by the first tribunal and it was never annulled, and surprisingly, the second tribunal walked away from this rule and established the U.S. prime rate plus 2%, and this also meant hundreds of thousands of dollars additional to TECO, and the tribunal never offered any reasons for these decisions. These grounds for annulments are evident, and they are the result of a simple reading of the award. You do not need to study this in depth to establish the existence of these reasons. Any reader quickly runs into these contradictions that cannot be explained, not even with the thoughtful explanations provided by TECO counsel who need to go in depth to try to find reasons for the award that are not even there as they should have been. They also produce serious detriment that become millions of dollars for the government of Guatemala.